thank you for joining me today. Today we're going to be talking about the broad topic of technology and the Constitution, from focusing on compelled passwords, more specifically the government's ability to compel people to provide passwords to their digital devices. Learning objectives today are going to be discuss compelling people to give law enforcement their digital passwords, understanding how the courts have had different opinions about this topic and how they apply under Fifth Amendment protections, understand the arguments for and against compelled passwords, and discuss the broader implications of applying constitutional protections to modern technology. And then finally, we'll discuss the writing assignment that's going to be due on this topic for your next class. Let's start with the scenario, and I want you to keep the scenario in mind as we go through the lecture and how it would apply to this specific fictional suspect. A man is arrested for stealing a car. Law enforcement has probable cause to believe that he has stolen several cars in the city and has pictures of all the vehicles he has stolen saved on his phone. They realize that they need this digital evidence to get a conviction. The police work with the district attorney to obtain a lawful warrant to search his phone. However, the phone is password protected. They take the phone to the forensic lab, and they're told the password is 10 digits that are alphanumeric, and it'll take about 25 years to break into the phone with the existing decryption software. They ask the suspect for the password, but he refuses to answer. Can the police compel the suspect to give him the password under threat of obstruction of justice? That's going to be kind of the topic we're discussing today. Can the suspect deny to answer and claim that it's a violation of his Fifth Amendment rights? Well, let's take a quick look at the Fifth Amendment. The part we're going to be primarily concerned with is the part there highlighted that says a person shall not be compelled in any criminal case to be a witness against himself. How has this been applied? Well, there's several Supreme Court cases that talks about compelling suspects to give up information in criminal proceedings. We're going to look at three specifically that have been applied to the question of password protection. The first one we're going to talk about is Fisher versus the United States. Fisher was asked to hand over tax documents to the government, and he said he refused, and that was a violation of his Fifth Amendment right not to incriminate himself. The Supreme Court found in 1976 that because the government knew that the documents existed and they belonged to the suspect, simply producing the documents that were known to exist and the fact of their existence and placement was a foregone conclusion that did not fall under Fifth Amendment protections, because he's providing a document that's known to exist, not providing testimony against himself. Another landmark decision on this topic was Doe versus the United States. This was in 1988, and it was surrounding certain bank records, and the government requested that the suspect sign a document that gave the government access to all of the relevant bank statements, documentation. The Supreme Court found that the government could request a signature because signing over the release of the bank records is not in itself a testimonial act. You're just providing a signature to give government access to evidence it believes exists. Again, this evidence is physical in nature. They know it belongs to the suspect, and they know where it is and that it does exist. So that would again fall under the foregone conclusion exception for the Fifth Amendment. On the other hand, in the United States versus Hubble case of 2000, and this was a lawyer that they were trying to convict of tax evasion. Law enforcement made a broad request for something like 3 years of documents and all documents that refer to any sources of money, direct or indirect. The Supreme Court found that given the broad nature of this request to search, it would require Hubble to use the contents of his own mind to find and identify hundreds of documents, and this act would be considered testimonial in nature, therefore protected by the Fifth Amendment. Specifically of note here, what the judge stated in the case was that asking somebody to provide a physical object for access, like a key to a safe, is different in nature than asking somebody to provide a combination to a safe, because the key is a physical object that the government knows to exist, and a person would have to hand that over. However, they would not have to hand over something that's in the contents of their mind. That's a critical point there. Can the government force somebody to give up the contents of their mind?